Turning now to a number of important developments from downtown Manhattan late this afternoon in the midst of a crucial stage in that $250 million civil fraud trial targeting the Trump family businesses brought by New York Attorney General Letitia James. Today, a notably fidgety Eric Trump wrapped up his testimony. He was combative with the AG's office, more so today than yesterday. We'll tell you more about his raised voice testimony in a second, because breaking in just the last hour, the judge in the case has issued an expanded gag order ruling that Trump's attorneys can no longer make any public statements in or out of court about communications between the judge, that's Judge Engoron, and his staff. It's an angry crescendo to a tension we told you about as it was brewing yesterday. Donald Trump's team repeatedly insinuating bias on the part of the judge's clerk. It happened again today. Trump's team making dubious accusations, a manufactured sideshow, in the word of the AG's office. During trial today, Judge Engoron had this to say, quote, "This allegation is untrue. It's a shame we have descended to this level," he said, adding, quote, "I don't want any further comments about my staff." Joining us at the table, Sue Craig of the New York Times. Andrew and David are still with us. Sue, we'll deal with the gag order and what is clearly an effort at sort of manufacturing a circus, which the Trumps are, if nothing else, very good at. But let's talk about the legal setbacks that may have made that necessary.
Well, I think this is proven to be, I wouldn't say an effective distraction, but a distraction. And that came on the heels of Eric Trump's testimony, which I would say was pretty rocky. He was on the trial he was on the stand for about a day and a half, and he had various defenses that they just sort of went from bouncing from one to the other, and all of them were. I think everybody in the courtroom, my head was kind of spinning, and it started out. I actually put a list together.
Okay, let's go through it. Yeah.
The first one is, I was busy doing other things.
Pouring concrete.
Pouring concrete.
I have this mental image of him like with a juice container, like pouring. Like, what is that? What?
That's, and they don't have a lot of new construction, so I don't even know what that is. But he's busy out working on properties. He's pouring concrete. He's too important to be worried about, and he specifically said appraisals. So he's too busy doing other things. But then the Attorney General, I thought it was, and it very neatly did this. They took his the depositions that he gave last year, and they played them in court, where he was saying he doesn't know a lot about the appraisals and other issues that are going on at the company that affect this case. And then the Attorney General came into court this week and just put on the screen email after email after email. The repetition was very effective in what they did, and showed that he was right in the weeds of a number of appraisals that are at the heart of this case. So that was, I thought, really effective.
Wow.
And then the second...
Which ones did they have? Because I've heard of the seven.
So Seven Springs is the estate out in Westchester. There's been a lot of discussion about it. Donald Trump bought it in the 1990s. He tried unsuccessfully to make it into a golf course and put housing out there. And they have got an easement on that. And what that means is they've just tried to then donate some land in order to get tax breaks from it. So that was one of them. And there was another golf course that came up. But it was clear, and there's just a few properties that the Attorney General's looking at on this, and these were, and so he was saying, no, I didn't have a lot to do with it. And the emails really, I think, credibly sort of shot that down to anybody sitting in the courtroom. At least that was sort of my take on it.
Yeah.
And then the second one was, well, we relied on professionals. We have outside accountants, we have outside lawyers. And so, I'm busy doing things.
Pouring
concrete. So I rely on these guys. And that was interesting until you sort of obviously start to think that through. And we've had accountants and lawyers and everybody come into the courtroom saying, well, we just relied on the information that the Trumps gave us. So that was their second defense was. And then the third one is, well, it doesn't even, none of this even matters because there's nothing to see here, because the financials are not only perfect, they undervalue our father's assets. They're actually worth even more. So they're bigger, they're better, they're bigger, and so nothing to see here. So
how did that go?
I didn't think it was. I was like, my head was spinning at times, because you're just trying to think, like, what? They were throwing all this stuff out.
One of the problems, as we were talking about before we came on, was Eric started by saying, I don't even know we had financials. Right. Okay, I do know that we had financials, because of course we had financials, but I don't know anything about them, to later saying, but the financials are perfect, to know the financials undervalued. So that's one of the reasons that you had to keep a chart of the defenses, because they're so, it's like, I didn't do it, but if I did do it, this was my mental state. And it was just so inconsistent. I really don't think he helped himself.
And if I did do it, they were perfect anyways.
Can you commit a crime? I mean, this is a civil proceeding. Nobody faces jail time. Donald Trump has already been hauled onto the stage. If he violates the gag order, he could, snatch some jail time from the jaws of a civil proceeding. If you perjure yourself in a civil proceeding, can you be charged?
Yes, you can. You obviously need to be able to prove it beyond a reasonable doubt. So it's very different than the civil standard, what the judge is deciding here, which is just a preponderance. So that is 50% and a hair. So that is a very different, much lower standard. But it is worth remembering that this whole case started with the Manhattan District Attorney's Office looking at financial fraud as a criminal investigation. One of the things that I used to do was look for false statements, look for perjury, because you usually don't have to lie if there's no underlying problem. So none of this is going to be particularly helpful to the Trumps with the Manhattan District Attorney's Office still looking, because that case is not closed, according to DA Bragg. So it is possible. It is possible also to have just a standalone perjury count. But I think for the moment, the main issue is that in terms of this civil case, I agree with Susanne, at least the last couple of days have not been good for the Trumps. Right.
David Jolly, let me bring you in on this. There's something so on brand, right, about where it devolved. It devolved into a gag order extending to the Trump team's attorney. But of course it did, right? Because when you're losing on the law and you've already been found liable for fraud, which is where this started. This started with the Trump family, Eric and Don and Ivanka. I guess she's not a defendant. Eric and Don and Donald Trump being liable for fraud. You don't have, you're not playing to win anymore. But I wonder what you make of the spectacle they've made of themselves.
Yeah, I'm so glad that Sue was able to kind of articulate the different defenses, because it perfectly represents kind of every Trump legal proceeding, every accusation against the former president, regardless of jurisdiction or forum. And it's this: there are always two contradictory arguments that they make. First is the smartest person in the room argument that, well, regulators don't know what they're talking about. Banks don't know. Prosecutors don't know. The attorney general doesn't know. We're the smartest people in the room, so why would you question us? But then they go to the dumbest person in the room, which is, oh, I didn't know anything that was going on. I had nothing to do with this. I have no idea what you're talking about. And ultimately, this is the fascinating thing. When it really gets down to it, when they feel that they are really in trouble, either facing criminal culpability or or civil liability, they often come down to relying on the dumbest person in the room defense, that I had no idea what I was doing was wrong. It's really a fascinating trajectory. But then they inject, to your point, something very critical, which is intimidation and harassment. And whether it is using kind of the cultural movement that they've created to come down with intimidation and harassment that leads to a gag order, or whether it is something that leads to the violence like January 6th, that also is kind of the final thematic, which creates the danger around much of these proceedings. But again, if we didn't have the proceedings, we'd probably end up in an even more dangerous space.
Yeah, let me turn to the gag order. This is... The gag order was amended, I understand it, to add Chris Keiss, the Trump side's lawyer. Let me read from some of it. This is how it starts. On October 3rd, the defendant Donald Trump posted to his social media account an untrue, disparaging, and personally identifying post about my principal law clerk. I imposed on all parties to this action a very limited gag order, forbidding all parties from posting, emailing, or speaking publicly about any members of my staff, emphasizing quite clearly that personal attacks on members of my court staff are unacceptable, inappropriate, and I will not tolerate them under any circumstance. I further made clear that failure to abide by this directive will result in serious sanctions. Go to October 20th. Upon learning Trump failed to remove the post of from one of his campaign websites, for 17 days, I imposed a fine of $5,000 against Donald Trump for violating the gag order. On October 25th, after conducting a brief hearing, I concluded that Donald Trump had intentionally violated my gag order by stating to a gaggle of reporters outside the courtroom the following statement in reference to my principal law clerk, quote, "This judge is a very partisan judge with a person who's very partisan sitting alongside him, perhaps even more partisan than he is. And I fined him an additional $10,000. I imposed the gag order only upon the parties operating under the assumption that such a gag order would be unnecessary upon the attorneys who are officers of the court." Fast forward to where we are today. Over the past week, defendants' principal attorneys, namely Christopher Keiss, Clifford Robert, and Alina Habba, have made on the record repeated inappropriate remarks about my principal law clerk, falsely accusing her of bias against them and improperly influencing the ongoing bench trial. Defendants' attorneys have made long speeches alleging that it is improper for a judge to consult with a law clerk during ongoing proceedings and that the passing of notes from a judge to a law clerk or vice versa constitutes an improper appearance of impropriety in this case. The arguments have no basis. And here's the punchline. A judge may consult with court personnel whose function is to aid the judge in carrying out. He cites the law. And he concludes by saying, as I have made clear, the judge in this case and the trier of the fact, the gag order does not apply to me. However, I will not tolerate under any circumstances remarks about my court staff. The threat of and actual violence resulting from heated political rhetoric is well documented. Since the commencement of this bench trial, my chambers have been inundated with hundreds of harassing and threatening phone calls, voicemails, emails, letters, and packages. The First Amendment right of defendants and their attorneys to comment on my staff is far and away outweighed by the need to protect them.